877-381-3811, and I'm hearing it all day. Political spin, commentator spinning, radio hosts who don't know what they're talking about spinning. It's very painful. So you have all kinds of information coming at you on the internet, on network TV, cable TV, on the radio. You really need to sort through it. I keep hearing that the court narrowed the Commerce Clause. 5 justices narrowed the Commerce Clause. No, they didn't. Nothing happened to the Commerce Clause. The case was decided on the tax issue, which was absurd enough. Oh, but Mark, 5 justices. 5 justices said that Obamacare couldn't fly under the Commerce Clause. So what? Was that in a majority opinion? No. Did the dissent and the Chief Justice join in their opinions in that regard? No. I'm hearing this from lawyers. Now, this may seem a little technical to you, but it is not a minor matter, so I want to walk through this, and I posted this on my social sites, and it's posted by my friend Catherine Lopez Kalo at National Review Online on the corner, apparently. Like I said, a number of politicians and commentators are claiming the Supreme Court in the Obamacare case limited the reach of the Commerce Clause. That is, 5 justices held that individuals cannot be mandated to buy insurance under the Commerce Clause. But the 5 justices didn't limit anything. They simply did not accept the Obama administration's ridiculous argument that inactivity is commerce. So the status quo stands because Obamacare was upheld under the tax provisions. And the abuse of the Commerce Clause has been enormous and will remain enormous. But I have a bigger point. Please follow me on this. When a court issues an opinion, it is said to be, quote, the opinion of the court, unquote. Got that? The opinion of the court. The opinion of the court is the controlling precedent in a case. Not the opinion of 1 justice or 4 justices or 5 justices or all 9. It has to be part of the opinion of the court. Chief Justice Roberts wrote the opinion of the court for Parts 1, which was the background on the Obamacare law, 2, the Anti-Injunction Act, that is, not to bar the lawsuit from proceeding and being decided, and 3C, that Obamacare is valid under the tax power. But Part 3A, the Commerce Clause, and I might add the Necessary and Proper Clause, the decision specifically notes that Roberts is writing, quote, for himself, unquote, not for the majority. You see, words have meaning, the language is in there for a purpose, and so people like me pay attention to those words. I was hearing this all day, part of yesterday. Oh, well, we won on the Commerce Clause. It's limiting the Commerce. So I went back and I said, this needs a little bit more examination here. So, Part 3A, the Chief Justice is writing for himself, not for a majority, not for any majority. Furthermore, the dissent on that issue is labeled as Justice Scalia, Justice Kennedy, Justice Thomas, and Justice Alito dissenting, quote unquote. It's not labeled as, quote, dissenting in the judgment, but concurring in part, or some permutation of that sort, which is required for there to be 5 justices, or majority of the justices, agreeing on a specific issue. You cannot say it was the opinion of the court that the mandate violated the Commerce Clause. You have to cobble together sections where Roberts is writing for himself and the dissent which didn't formally join with Roberts, is writing for itself. These are smart people. Doesn't mean they always do smart things, but these are smart people. If they wanted it to be the opinion of the court, they would have made it the opinion of the court. See my point? Technical but crucial to understanding how these cases are read, how they're decided, and how you litigate. In fact, Justice Thomas, in his separate dissenting opinion, he wrote this on the Commerce Clause issue. Quote, the joint dissent and the Chief Justice correctly apply our precedents to conclude that the individual mandate is beyond the power granted to Congress under the Commerce Clause and the Necessary and Proper Clause. So notably, this does not state that the dissenters explicitly join with the Chief's opinion respecting the Commerce Clause in any way. If 5 justices had intended for their view of the Commerce Clause to be controlling as the majority view, that is, the opinion of the court, they would have said so by joining or concurring in each other's parts. They didn't. There is no formal majority on the Commerce Clause issue. So stop listening to these people who are running around telling you, well, at least they limited the Commerce Clause, when in fact, number one, the Commerce Clause wasn't limited. It's status quo. Just because they didn't buy what the government said doesn't mean it's limiting. They just didn't blow it up. Number two, there is no opinion of the court, an official, formal opinion of the court upholding the Commerce Clause, that is, throwing out the individual mandate. And the reason, why would this happen like this? I think there's a few things here. I think it is now abundantly clear, having now read this over 200 pages of opinions 3 times, that the court is not a happy place. I don't think there's any doubt that John Roberts switched sides at the 11th hour, that he stabbed the dissenters in the back. I don't think there's any doubt when you look at what the dissent is saying about Ginsburg's opinion. She's concurring in the majority. They speak of her as a dissenter. That Roberts' change of heart came rather late in the game, and the 4 dissenters were left holding the bag and did the best they could to respond. That's why, in my humble opinion, I don't know anything firsthand, obviously. I'm trying to use logic. That's why the 4 dissenters didn't join Roberts on the Commerce Clause, either because they've had enough of his games or they didn't have time. But the fact of the matter is, they didn't. Now, you'll hear lawyers say in response to me, but it's still 5 justices, so if you're going to take up a case like this, should it happen again? It doesn't have to happen again because Roberts showed them a way out. He concocted one. But that aside, you can still count on 5 justices. Somebody tells you that, it just tells you that they're not that thoughtful. Maybe you can count on 5 justices, maybe you can't. But the opinion of the court, as formally presented, did not have 5 justices joining together officially, formally, in rejecting the Commerce Clause argument. Sorry. Now, another point I've been hearing all day, but the good news is, we're told, as if we have to find good news in this, rather than dealing with reality so we can fix the situation. Because it's a tax, we only need 50 votes plus a Republican vice president or 51 votes in the Senate as well as a majority in the House to overturn this because it's a tax matter. That's the good news, we're told. The good news? What do you mean the good news? This case was a black and white case. This case was actually a very easy case. When you have a case in front of the Supreme Court where Congress and a president have done something so outrageous, so extraordinary, so outside the norm when it comes to the Constitution. That is, trying to regulate inactivity. And given all the left-wing courts we've had and all the left-wing presidents and Congresses that we've had, no Congress, no president, no court's ever done this. This was a slam-dunk case. Right? And yet we're supposed to take solace in the fact that the law survives, but because it's called a tax, all we need are so-and-so number of votes and blah, blah, blah. Great damage was done to the Constitution yesterday. Great damage was done to the Constitution yesterday. This law should have been killed where it should have been killed, right there, under the watchful eyes of the justices, protecting and preserving the Constitution. They didn't do it. 5 of them didn't do it. No good news in this. Well, Mark, what about the Medicaid decision? The court said, look, states don't have to join this new Obamacare exchange program, and they can't be punished so fully that funds they get for Medicaid apart from this can be denied them. Well, that's good. But if the decision had been to kill the act, that entire issue would be dead, wouldn't it? So this notion of good news is bizarre to me from a constitutional point of view. And from a political point of view, things still have to happen. So pushing it down the road is not good news. The Constitution being damaged is not good news. When justices rewrite the Constitution and a statute, that's not good news. Expanding the taxing powers of the government without even identifying which taxing powers we're expanding, that's not good news. This whole thing is crap. And don't let anyone else tell you differently. More when I come back.
Mark Levin.